Okay. Good afternoon. Okay, let us continue our discussion on revised Corporation Code of the Philippines. Okay? Bali, ginawa ko na tong part 7. Okay, let us discuss, okay, Ultra Vires Act. Okay, kasi yung part 6, okay, we end of course dun sa, okay, bylaws. Now, let us discuss yung Ultra Vires. Okay, pag sinabing Ultra Vires Act, it means the corporation perform an act outside the express, implied, or incidental power. Okay? Now, however, if the corporation perform an act within the express, implied, or incidental power, then we call it an Intra Vires Act. Okay, now ang question dito is that, what is the contract entered into by a corporation act Ultra Vires? Okay, some say that the contract of this corporation is unenforceable. Pursuant to Article 1317 in relation to 1403, Paragraph 1 on unenforceable contract. Kasi kung marirecall nyo, di ba meron tayong tatlong grounds for unenforceable contract. Number 1, okay, unauthorized contract. Second, okay, hindi na-comply yung requirement ng statute of fraud. And number 3, when both contracting parties are incapable to give consent. Kaya lumalabas sa 1317, sabi dyan, those entered into in the name of another person by one who has been given no authority or legal representation or was acted beyond his powers is unenforceable contract. However, sabi ng Supreme Court sa case ng Maria Clara versus De La Rama Steamship Company, okay, illegal act of a corporation contemplate the doing of an act which is contrary to law, morals, or public order, or contravene some rules of public policy or public duty, and are like similar transaction between individuals void. They cannot serve as basis of a court action nor acquire validity by performance, ratification, or estipel. Okay, on the other hand, Ultra Vires Act or those which are not illegal and void ab initio but are merely within, okay, the scope of the article of incorporation are merely voidable. Okay, and may become binding and enforceable when ratified by the stockholder. By the way, class, ang nagra-ratify, okay, syempre dun sa act ng Board of Directors is the stockholder. Pero syempre yung Board of Director ang nagre-represent dun sa corporation. Pero sinasabi dito ng Supreme Court, merely voidable siya. Kaya ibig sabihin, kung voidable lang siya, subject yan sa ratification. Pero by the way, dinistinguish dito, okay, yung illegal contract from merely ultra vires. Kasi pag sinabi nating void contract, okay, ito yung mga, or illegal act, simple ito yung act na contrary to law, moral, good custom, public order, public policy, and therefore hence null and void siya. Null and void. Kaya wala siyang binding effect. Okay, unlike yung pure ultra vires, nag-act lang yung corporation outside, okay, the power conferred. Kaya lumalabas, subject yan sa ratification. Okay, kaya tandaan nyo, pag illegal act, void, not subject to ratification. Pero pag pure ultra vires act, merely voidable and therefore subject to ratification. Therefore, meron tayong conclusion. Lahat ng illegal act ay automatically an ultra vires act. But not all ultra vires act are illegal act. Kasi pwedeng nag-act nga lang yung corporation outside the express, implied, or incidental power. However, according to Agbayani in his book, okay, merong limitation ang ratification. Number 1, it must be ratified by all the stockholders. By the way, merong question sa CPA board exam before. Okay, I think mga 80s pa tinanong. Tinanong doon is, ilan ang voting requirement for ratification of a pure ultra vires act? Okay, wala sa choices ang ratified by all stockholders. Pero may nakalagay na 2/3 of the outstanding capital stock. It seems that the answer there is 2/3 of the OS. Pero sabi mo sir, may nakalagay ang all stockholder. I think mas tama yung all stockholder. Siguro nag-assume lang sila na ratification pagdating sa ultra vires is 2/3. Kasi mapapansin mo, halos lahat ng ratification is 2/3 ng outstanding capital stock. But take note that is true only in case of self-dealing director. Do sa interlocking director. Disloyalty of director. Okay? 2/3. Pero ang problema, pag binasa mo yung provision sa corporation law, walang nakalagay na ang ratification sa Ultra Vires Act is 2/3 of the outstanding capital stock. That's why according to Agbayani, dapat it should be ratified by all stockholders. Reason, in order to avoid a possible derivative suit. Kasi di ba kung ang concept ng derivative suit, pwedeng mag-initiate ng action ang stockholder in the name of the corporation. Pero kung nag-ratify lahat ng stockholder, then no one can initiate a possible derivative suit. Kaya nilagay na all stockholders. At walang basis yung 2/3 of the outstanding capital stock. Pero by the way, in case may encounter mo yun, kung nakapiuli yung question na yun, since wala sa choices yung all stockholders, then 2/3 of the outstanding capital stock. Now second, hindi kayo pwedeng magkaroon ng ratification, okay, kung affected ang creditors. And last, when the right of the state or the public are not involved. Kasi the moment na involved na ang public interest, hindi pa rin yan subject sa ratification. Kasi yan ang limitation, okay, nung ratification. Now, ano ba ang effect ng illegal contract? Kapag halimbawa yung illegal act, okay, or legal contract nag-constitute as a criminal offense, in that case, both parties are in pari delicto. And therefore, both parties has no remedy against each other. Kaya lumalabas as is siya, both parties shall suffer their own respective damages. Pero kung halimbawa hindi naman siya nag-amount to a crime, meaning yung illegal contract hindi nagko-constitute as a criminal offense. Okay, alamin mo muna, are both parties at fault? Pag ang sagot ay yes, then sabi dyan, neither may recover what he has given by virtue of the contract or demand the performance of the others undertaking. Okay? Pero when only one of the contracting parties at fault daw, yung at fault, syempre wala siyang remedy under the law. Kaya nakalagay yan, cannot recover what he has given by reason of the contract. Pero yung not at fault, pwede siyang mag-demand ng return of what he has given without any obligation to comply with his promise. Okay, now let us proceed now sa meeting. Okay, ito, paki-check nyo maigi. Okay, kasi may mga changes dito from BP 68 to Republic Act 11232. Okay, first distinction between directors meeting and stockholders meeting. Sa directors meeting, of course, bawal ang proxy. Kasi nga, okay, mababiolate yung doctrine of agency that what has been delegated can no longer be further delegated. Sa stockholders meeting, of course, proxy vote allowed. Okay. Proxy vote, of course, allowed siya. Okay, kasi ang sabi nga ng Supreme Court, whatever a man may do in person, it can be done through an agent. Second, date of meeting. Sa directors meeting, ang regular meeting ng director is held monthly. Of course, unless the bylaw provides otherwise. Okay, pag special meeting, of course, at any time. Okay, upon call of the president or as provided in the bylaws. Pero whether regular or special meeting, kailangan daw dito ng notice of meeting na at least 2 days. Okay, prior to the intended meeting. Okay, unless the bylaw provides otherwise. Uli. But of course, the notice of meeting may be waived either express or implied. Pero pag tinignan mo sa stockholders meeting, okay, lumalabas. Pag regular meeting, okay, as fixed by the bylaws, okay, if not, okay, any date after April 15th. Okay? Now, plus, meron daw na written notice na 21 days prior to the meeting unless the law, regulation, or bylaws so provide. Kasi dati, sa Batas Pambansa Bilang 68, pagdating sa regular meeting with stockholders, at least 2 weeks. Pagdating naman sa special meeting, at least 1 week. Pero dito, ang ginawa, binago. Okay? Pag stockholders meeting, 21 days na. Okay? Pagdating sa special meeting naman, of course, okay, ay 1 week. Okay? Parang na-retain siya. Now, next. Okay, sa place of meeting naman. Okay? Sa directors meeting, anywhere daw. In or outside of the Philippines. Unless the bylaw provide otherwise. Kaya ibig sabihin, pagdating sa directors meeting, anywhere. Okay? Kahit outside of the Philippines yan. In or outside of the Philippines. Unless the bylaw provides otherwise. Pero sa stockholders meeting, okay, sabi yan, it must be within the principal place of business. Okay? Principal office ng corporation set in the article of incorporation. Pero kung halimbawa, if not practicable daw, then within the city or municipality where the principal place of business is located. Okay? Pero for purpose of this provision, Metro Manila, Metro Cebu, Metro Davao, and other metropolitans are considered city or municipality. Kaya sabi ko nga sa inyo, kung halimbawa, ang nakalagay sa article is Makati City, nag-meeting kayo sa Quezon City, that is within, okay, that is a proper venue because that is within Metro Manila. Pero kung halimbawa, ang nakalagay sa article is Makati City. Nag-meeting kayo for instance sa okay, sabihin natin plus sa Bulacan. That is already outside Metro Manila. That's why improper venue siya. Kaya any stockholders who are absent may question what transpired during the meeting. Okay? Now, okay, sa manner of voting naman. Sa directors meeting, pwede kasing mag-vote okay ang director either in person or through remote communication such as video conferencing, teleconferencing, or other alternative mode of communication. Okay? Now, sa stockholders meeting, pwede kayong mag-vote either in person or a written proxy. Okay, pero pwede rin remote communication kung authorized ng bylaw or majority ng board of directors. Pero sabi ko nga, di ba may exception yan. Pag kahit na hindi siya authorized sa bylaws, pero okay, imbued with public interest, pwede pa rin ang voting through a remote communication. Next, quorum. Okay, sa directors meeting, majority ng board of director trustee na naka-fix in the articles. Okay, of incorporation. Unless the article or the bylaw provides a greater majority. Okay, binanggit ko na sa inyo to before. Okay, kaya pwede siyang dagdagan, hindi siya pwedeng bawasan. Okay? Samantalang sa stockholders meeting, majority ng outstanding capital stock or majority of the members. Okay, now, sino nag-preside ng meeting? Okay, sa RA 11232, chairman. Okay, dati kasi president eh. Pero ngayon, ang nakalagay, chairman na. Pero in his absence, the president shall preside. Okay, unless the bylaw provide otherwise. Okay, kaya ito, changes din yan. Okay, chairman. Okay, postponement of stockholders or members regular meeting. Sabi dyan, unless a different period is required under the bylaws, laws or regulations, okay, kailangan daw ng written notice thereof and the reason thereof shall be sent to all stockholders or members of record at least 2 weeks okay, prior to the date of the meeting. Kaya kung magkakaroon kayo ng postponement for instance ng meeting, Okay? Kailangan nyo magbigay ng notice. Okay? Na sinasabi at least 2 weeks prior to the date of the meeting. Okay? Sa notice of meeting, sabi dyan, shall be sent through means of communication provided in the bylaws. Ano ba yung content ng notice of meeting daw? Nakalagay syempre yung time, yung place, and of course yung purpose ng meeting. Okay? Yan yung nakalagay sa notice of meeting. Okay? Time, place, and of course yung purpose. Okay? Ngayon, ito attachment to the notice of meeting, masyadong mahaba to. Okay? And I think naman, hindi naman siya itatanong of course ng examiner. Sabi dyan, each notice of meeting shall further be accompanied by the following. Siyempre, kailangan naka-indicate yung agenda. Ano ba yung pag-uusapan? Ano ba agenda sa meeting ng stockholder? Proxy form. Okay, which shall be submitted to the corporate secretary. Okay, within reasonable time prior to the meeting. Kasi normally, di ba, kung hindi makaka-attend yung stockholder, okay, minsan nagbibigay sila ng proxy form. Okay, kaya ang a-attend rito, of course, yung proxy. Pero kailangan i-file yan sa corporate secretary prior to the intended meeting. Ngayon, when attendance, participation, and voting are allowed by remote communication or in absentia, the requirements and procedures to be followed when a stockholder or member elect either option. Pero di ba sabi ko sa inyo, allowed lang naman yung voting by absentia or through remote communication kung authorized ng bylaws or majority ng board of directors. Okay, ang exception nga lang, pag yung corporation ay imbued with public interest, even though hindi siya authorized sa bylaws, okay, allowed pa rin ang voting by absentia or through a remote communication. Okay, now ilalagay nyo lang dito yung requirement and procedure to be followed. Now, okay, at each regular meeting of stockholder or members, the board of directors trustees shall endeavor to present to stockholder or members the following. Okay, now yung minutes of the most recent regular meeting, which shall include among others, okay, description ng voting and vote tabulation, procedure lang to. Description of the opportunity given to stockholders or members to ask questions and record of the questions, asked and answer given. The matters discussed and resolutions reached, record of the voting result for each agenda item. List of the director, trustee, officers, and stockholder or members who attended the meeting. Okay, such other items that the Commission may require in the interest of good corporate governance and the protection of minority stockholders. Tapos letter B, okay, mahaba kasi ito. Yan yung nakalagay na okay, included rito. Okay, yan yung i-represent of course sa stockholders, okay, during the regular meeting. Members list for non-stock corporation, okay, and for stock corporation, material information on the current stockholders and their voting right. Detailed descriptive balance and comprehensive assessment of the corporation's performance, which includes information on any material change in the corporation business strategy and other affairs. Siyempre, financial report, diba? Okay, siyempre pag regular meeting, dapat may financial report yan nung preceding year, which shall include financial statement duly and certified in accordance with the scope. And the rules, the commission may prescribe a statement on the adequacy of the corporation internal control or risk management system and a statement of all external audit and non-audit fees. Okay, siyempre ito yung isa sa mga pinaka-importante as investor. Explanation of the dividend policy. Kasi yan yung return ng mga stockholder. And the fact of payment of dividend or the reason for non-payment. Kasi kung walang dividend declaration, bakit? Okay, tulad ngayon, merong COVID. May possibility na yung bank corporation, they will not declare dividend. And of course, indicate nila yung reason. Okay? Director trustee profiles which shall include among others their qualification and relevant experience, length of service in the corporation, training and continuing education attended, and their board representation in other corporations. Director or trustee attendance report indicating the attendance of each director or trustee at each of the meeting of the board and its committees and regular special stockholders meeting. Appraisals and performance report for the board and the criteria and procedure for assessment. Another, a director trustee compensation report prepared in accordance with this code and the rules the commission may prescribe. Director's disclosure on self-dealing and related party transaction. Profiles of directors nominated or seeking election or re-elections. By the way, yung notice of meeting sa stockholders kasi, waivable naman siya. Pero bawal daw class magkaroon ng general waiver either sa Article of Incorporation or the bylaws. Kasi diba, may nakalagay na provision for instance sa article. Nakalagay doon that the stockholders waive their rights to the notice of meeting. A general provision state in the Article of Incorporation or bylaws is not valid. Okay, pero kung magkakaroon ng express waiver, for instance, yung individual stockholders, then that is a valid waiver. Kaya nga, kung babasahin mo yung batas, nakalagay dyan, notice of any meeting may be waived, pwedeng express or implied, by any stockholder or member. Pero sinasabi dito ha, yung general waiver sa Article of Incorporation or bylaws, that is not a valid waiver. Pero another, sabi dyan, the attendance at a meeting shall constitute a waiver of notice of such meeting. Kasi halimbawa, stockholder ka, hindi ka naman nakatanggap ng notice of meeting. Eh, ang problema, pagdating ng stockholders meeting, nandun ka. Okay? Sinasabi ng batas, yung presence mo doon, constitute na yan as waiver. Pero may exception. Kasi kung halimbawa, nandun ka for the sole purpose to question that you did not receive any notice of meeting. Okay, exception yan. Kasi ang sinasabi ng Section 49, when the person attend the meeting for the express purpose of objecting to the transaction of any business because the meeting is not lawfully called or convened. Kaya ibig kung nandun ka for the sole purpose na questionin nga, okay, na hindi siya lawfully called or convened, then that is not waiver on the part of the stockholder. Pero ang rule kasi, pag umattend of course yung stockholders, kahit wala siya natanggap na notice of meeting, then that constitute as waiver on his part. Now, by the way, sino ba yung proper person to call a meeting? Kasi take note guys hindi pwedeng kahit sino-sino lang ang pwedeng mag-call ng stockholders meeting. Kailangan proper person siya. Okay, sabi mo sir, ganun ba yun? O bigyan ka ng example. Halimbawa nagtawag ng stockholders meeting yung gwardiya. Eh hindi naman siya yung proper person to call a meeting, attend ka ba as a stockholder? Siyempre, the answer of course is no. Unless, okay, siya yung nakalagay sa corporate bylaws. Kaya ang tanong, sino ba ang pwedeng mag-call ng meeting? Okay, ang proper person to call a stockholders meeting of course is the person designated in the bylaws. Kaya kung sino naka-indicate sa bylaws to call a meeting of stockholders, then siya yung proper person. Ngayon, paano kung walang nakalagay sa bylaws? Then, pwede raw magtawag yung director or trustee or officer entrusted with the management ng corporation. Sabi mo, sir, wala. Walang nakalagay sa bylaws. Okay? Wala ring directors, trustee or officers entrusted with the management kasi lahat sila kunwari namatay. Lahat sila ay natodas. Okay, lahat sila na final destination. Okay, in that case, okay, ang sinasabi dito, okay, whenever for any cause there is no person authorized or the person authorized unjustifiably refuses to call a meeting, the commission daw, upon petition of a stockholder or member on showing good cause, therefore, may issue an order directing the petitioning stockholder or member to call a meeting of the corporation by giving proper notice required by this code. Kaya ibig kung walang director, trustee, or officers entrusted with the management, pwedeng mag-file ng petition ang stockholder sa SEC. Okay, at orderan ng SEC yung petitioning stockholder na mag-call ng special stockholders meeting. Okay, or mag-call ng meeting. The petitioning stockholder or member shall preside thereat until at least majority of the stockholder or members present have chosen from among themselves a presiding officer. Pero by the way, may mapapansin kayo ha. Pagdating sa special stockholders meeting for removal of corporate director or trustee, okay, ang rule, ang pwede lang magtawag dyan is only the secretary upon order by the president. Okay? Or kung ayaw mag-call syempre ng corporate secretary, okay? Then pwedeng magkaroon ng written demand ang stockholder representing or holding majority of the outstanding capital stock. Or in case of non-stock corporation, okay, majority ng members entitled to vote. Pero yan, specific yan for calling of stockholders meeting for okay, removal of director or trustee. Ngayon, a special meeting ng Board of Director or Trustee daw may be held at any time upon call of the President or as provided in the bylaws. Ngayon, ito, bagong provision to. Hindi mo siya makikita before sa Batas Pambansa bilang 68. Okay, yan yung period to close the stock and transfer book. Ngayon, syempre, unless the bylaw provides for a longer period, ang rule is that dapat yung stock and transfer book ay naka-close na. At this, pag regular meeting, 20 days before the scheduled date of the meeting. Pero pag special meeting, 7 days before the scheduled date of the meeting. Kaya tandaan nyo na lang, dapat okay yung 20 saka 7 days. 20 days for regular meeting and 7 days for the special meeting. Kailangan i-close na ang stock and transfer. Okay? Now, okay, voting by stockholder. Sabi natin, ang stockholder either pwede yung bumoto ay either in person or through a written proxy. Ngayon, kung authorized ng bylaws or majority ng board of director, pwede ang through remote communication or in absentia. Pero may exception tayo pag ang corporation ay imbued with public interest. Kasi kahit walang nakalagay na authorization coming from the bylaws, pwede pa rin ang voting by absentia. Okay? Now, next. Ito yung mga factor na i-consider in voting by absentia. Siyempre, company scale. Okay? Number of shareholders or members. Kasi kung sobrang dami ng stockholder, ilang libo, tapos magmi-meeting kayo sa principal place of the corporation. Okay? Convenient, di ba? Kaya kung sobrang dami ng stockholders, then magkaroon tayo ng voting by absentia or through a remote communication. Structure and other factor consistent with the basic right of corporate suffrage. Okay, general rule, sino ba ang entitled to vote? Natural kung sino yung stockholders of record. Okay, pero ang problema, what if I am a stockholder? Pero ang ginawa ko, plinedge ko. Okay, or minortgage ko yung shares of stock. Okay, ang tanong, sino ang entitled to vote? Siyempre, in general rule, is entitled pa rin dyan yung stockholder. Because in so far as corporate records is concerned, ikaw pa rin ang registered stockholder. Kaya makakaboto dito, okay, of course, yung stockholders pa din. Kaya sabi dyan, stockholders grantor shall have the right to attend and vote at the meeting of the stockholders unless the secured creditor is expressly given by the stockholder grantor such right in writing which is recorded in the appropriate corporate book. Kaya ibig sabihin kung sino yung stockholders, lumalabas yung pledgor or mortgagor, siya pa rin ang entitled to vote. Unless nga, nag-execute siya okay ng written proxy in favor of the creditor. Pledgee, mortgage. Okay, kung halimbawa yung stockholders ay namatay, kaya obvious na yung stockholders hindi na makakaboto kasi patay na siya. Kaya lumalabas yung kanyang executor or administrator. Di ba pag sabing executor, ito yung person appointed in the will to settle the estate. Pero pag walang person indicated in the will to settle the estate, then the court will appoint an administrator. Kaya sinasabi dyan, executor, administrator, receiver, and other representative appointed by the court. Okay, pwede silang mag-vote even without any written proxy. Okay, pwede yung guardian of course. Halimbawa, stockholders, nabaliw siya. Naging incapacitated siya. Okay, dineclared siya of unsound mind. Bigla magkakaroon ng stockholders meeting, pwedeng umattend yung kanyang guardian. Kasi yan ay appointed by the court. Yung tinatawag na guardian ad litem. Now, treasury shares has no right to vote as long as they remain in treasury. By the way, pag tinanong dito, what class of shares has no voting right with respect to any corporate matters? Answer, treasury share. Huwag mo sasagutin yun ng non-voting preferred or non-voting redeemable shares. Kasi even they are classified as non-voting preferred or non-voting redeemable shares, but still, they are entitled to vote in 8 instances. Yung binanggit ko before na fundamental changes sa corporation. Okay, pangalawa, sino pa? Ano sir yung nag-exercise ng appraisal right? Kasi sabi ng batas, once nag-exercise ka ng appraisal right, lahat ng right mo stockholders ay hereby suspended, except the right to demand for the return of capital at fair market value. Sino pa? Delinquent shareholder. Kasi once ikaw ay dineclared as delinquent shareholders, hindi ka na entitled to vote with respect to any corporate matters. Okay? Pero entitled ka pa rin sa dividend. Yun nga lang, pag cash dividend, automatic o offset siya. Pero pag stock dividend, i-withheld until full payment of the entire subscription price. Ngayon, kung halimbawa, joint ownership of stock siya. Siyempre, kung joint stock ownership, okay, kailangan, sabi dyan, the consent of all the co-owner shall be necessary. Okay, when the share are owned in end or capacity by the holders thereof, any point of the joint owners can vote said shares or appoint a proxy therefore. Okay? Napunta tayo sa proxies. Okay, proxies must be in writing. That's why there is no such thing as oral proxy. It must be in writing and it must be filed with the corporate secretary prior to the intended meeting. Okay? Kaya yan ha, dapat in writing. Tapos, okay, dapat i-file mo yan sa corporate secretary before the scheduled meeting. Okay, sign and filed by the stockholder. Kasi unsigned document produce no effect whatsoever. Kasi kung wala yung signature ng stockholders, considered yan as a mere scrap of paper. Okay, any form authorized in the bylaws. Okay, tapos valid only for the meeting which it is intended unless provided in the proxy form. Kasi by the way class, ang nature kasi ng proxy temporary. Kaya halimbawa ako yung stockholder, binigyan ko ng written proxy si A. Ngayon ang rule, si A entitled lang yan to vote for that particular meeting. In fact, if the stockholder attended the meeting, automatic considered revoke ang proxy. Okay, kasi nga temporary lang ang proxy. Parang sa law on agency yan eh. Kapag yung principal directly minamanage na yung power given to the agent, considered impliedly revoke ang agency. Okay, kaya dito, once na umattend si stockholder, revoke ang proxy. At ulitin ko ha, valid lang yan for that particular meeting. Unless of course, nag-provide ka sa written proxy ng period. But in no case should exceed 5 years. Kasi ang maximum period lang na pwedeng ilagay sa proxy is only 5 years. Ngayon, yung voting trust agreement, ito mas more permanent siya. Para bang nagwo-work ang voting trust? Halimbawa, this is a corporation. Okay? Okay, tapos kunwari si A, si X, siya yung stockholder. Nag-execute siya ng tinatawag na VT in favor of Y. Ang tawag kay X is the trustor. Tatawagin natin si Y as a trustee. Ngayon, sabi ng batas, if a-file daw yan, the voting trust agreement must be in writing and duly notarized. If a-file yan sa corporation, at saka sa SEC. Okay? Ngayon, pag natanggap ng corporation yung voting trust agreement, ang gagawin ng corporation, ika-cancel yung certificate ni X and it will issue another certificate in favor of Y. Pero may notation that this was issued pursuant to a voting trust agreement. Okay? Kaya lumalabas, in-issue yun pursuant to the voting trust agreement. Kaya makakaboto dito ay si Y, not si X. Because in so far as corporate records is concerned, kinancelled na yung certificate mo. Nag-issue ng panibagong certificate kay Y. Okay? Pero yun nga, may notation. At valid dyan for the period indicated therein, but in no case should exceed 5 years. Kaya ang maximum period ng voting trust, 5 years. Pero may exception na pwede siyang maging more than 5 years kung in-execute ang VT pursuant to a loan agreement. Parang ganito kasi yan. Diba, stockholder ako. Okay, tapos ikaw creditor, nangungutang ako sa iyo kunwari ng 1 million. Sabi mo, okay, o sige, pahiramin kita ng 1 million, pero gusto ko mag-execute ka ng VT. Now, ilan nga yung terms ng loan natin? Ang terms ng loan is 8 years kunwari. O mag-execute ka ng VT for 8 years. Kaya lumalabas, valid siya sapagkat in-execute yung VT pursuant to a loan agreement. Pero may condition yan. Na once na-settle na yung entire obligation, automatic terminated ang voting trust agreement. Ngayon, pag nag-lapse yung 5 years dyan, ang gagawin, by the way, okay, di ba si Y yung trustee, siyang entitled to vote. Ang question dyan, pwede bang mag-execute si Y ng proxy in favor of Z? Answer, yes, kung walang prohibition sa voting trust agreement. Ngayon, pag nag-lapse yung 5 years, ang gagawin ng corporation, ika-cancel yung certificate nito, mag-i-issue ng another certificate sa original stockholders. Kaya doon lang mare-restored ang right ng stockholders to vote. Okay, o yan ang mga tatandaan nyo sa voting trust ha. Kailangan in writing at dapat duly notarized. Tapos i-specify nyo yung terms and condition. Ipa-file sa corporation, saka sa SEC. Kung may period siya, maximum period is 5 years. Exception, kapag yan ay in-execute pursuant to the loan agreement. Pero take note, once nabayaran na yung entire loan, automatically expire siya. Now, the certificate of stock covered by the VT shall cancelled and a new one shall be issued in the name of the trustee. Now, the book of corporation shall note the transfer. Now, voting trust agreement shall be entered into for purpose of circumventing the law against anti-competitive agreements, abuse of dominant position, anti-competitive mergers and acquisitions, violation of nationality and capital requirement, or for perpetration of fraud. Ngayon, sabi dyan, automatically expire siya at the end of the agreed period. Pero, pwede siyang i-renew. Kaya dito, kung 5 years yan, automatic once nag-arrive yung period, expired siya. Pero pwede siyang i-renew. Ngayon, pwede siyang mag-vote daw, maybe voted by proxy unless the agreement prohibited. Kaya sabi ko nga, kung si Y yan, ang trustee, pwede siyang mag-execute ng proxy in favor of Z. Okay? And that is allowed. Kung walang prohibition sa voting trust agreement. Okay? Stop muna tayo dito. Okay? Gawa tayo ng panibagong page. Okay, thank you. And goodbye.